Thanks, Deputy Speaker, and I rise to contribute to the Wage Theft Amendment Bill 2025, and I'm pleased that those opposite are not opposed to this bill. And again, I reiterate what the member for Croydon said, and that was that we're all against wage theft. Unfortunately, there are some employers that thrive on wage theft against employees, and it's a shame that that happens. I firstly want to start by giving a shout out to the mighty trade unions that represent their members on these issues. And my history is that I've also been involved in some, I'll call it underpayment of wages issues with the ambulance service some years ago, and I'll go to that a bit later in my contribution. But of course, the main function of this bill will be to repeal the Victoria's wage theft offence and associated record-keeping offences in light of the Commonwealth introducing similar offences intended to cover the field, ultimately making our offences inoperative. Of course, as a result of that, the bill will also repeal the Inspectorate's related investigative functions to better reflect this revised role. The Wage Inspectorate Victoria will be henceforth known as the Workforce Inspectorate Victoria, and this will in no way change the formal status of the Inspectorate, and it will continue to be an independent statutory authority led by the Commissioner. Of course, Victoria was the first state in Australia to introduce criminal offences aimed at the deliberate and dishonest underpayment of wages. And of course, we were also the first state to introduce industrial manslaughter legislation in protecting workers and keeping their workplace safer. So it's also become the only jurisdiction to establish an independent authority, and the Wage Inspectorate Victoria, with strong investigative powers to enforce these laws. But however, Victoria's wage theft laws were rendered largely inoperable after the Commonwealth introduced its own criminal offences, and the member for Croydon went to the history of the bills, both in the state and also the federal bill that was moved and carried. Of course, the federal bill comprehensively will regulate the enforcement of wage underpayments and other entitlements. And although some of Victoria's related record-keeping offences were not covered by the Commonwealth's provisions, the Allen Labor government has chosen to repeal all of Victoria's offences to eliminate uncertainty for workers, businesses and the broader community. And of course, by doing this, we've made it easier for all to understand and access these laws, so we've made it simpler. Of course, the Inspectorate complaints, we'll go to the Inspectorate complaints referral function, and it's a key objective of this bill is to implement recommendation 1 of the Wilson Review, as we've just been informed by the member for Croydon, into the Victorian Government's engagement with construction companies and construction unions. And it does so by granting the Workforce Inspectorate a complaints referral function, which enables it to receive and refer complaints from any person in relation to any public construction. Of course, this new service will be responsible for receiving complaints and tip-offs about any improper conduct of public construction projects, and it ensures those complaints are referred to the appropriate investigating entity that are already in place, those entities, and do a great job. It will make it easier for those complaints to be made and provide a single doorway for people and complainants to raise their issues and for those issues to be actioned, with a particular focus on those complaints that involve maybe a threat to safety, and in particular safety of women in the workplace. Of course, we acknowledge that the Wilson Review recommended creating a brand new body to handle and refer complaints. But of course, that may be questioned why we haven't followed that to the letter. But the simple fact is it's far quicker, much quicker, and more efficient to give this function to already existing regulators, which we have, that already has the operational capacity, rather than building a whole new agency from the ground up. Of course, it's important that this approach aligns with the government's recent economic growth statement, which commits to halving the number of business regulators in Victoria rather than creating more regulators. And embedding the complaints referral service within an existing agency is the fastest and the most effective way to establish the new service. And it draws on the skills and experience that already exist in those regulators. So, of course, here in Victoria, the Allan Labor government recognises that wage theft is a systemic problem right across the state and right across the country, which is why we took the first steps before any other jurisdiction to ensure that employers who stole money or withheld money and entitlements from their workers, they would face the full force of the law. Of course, we on this side of the House always back our hard-working Victorians because all workers have a right to be backed and have the representation and to ensure that their hard-earned money is not being withheld or shortchanged by their employers. And as I said earlier, in my previous role as the Secretary of the Ambulance Union, I was involved in a number of underpayment issues, and in particular a big federal court case for paramedics across the state where they weren't paid their appropriate leave loading when they took leave. And this amounted to an outcome in the federal court of in excess of $8.5 million that was paid to paramedics that they were underpaid that leave loading in the past, and that was a big outcome in the federal court. And I can't say at times that the ambulance service deliberately withheld it. I think they just didn't understand or interpreted the enterprise agreement a bit differently to what we interpreted and what the law interpreted. So I think you have those circumstances where sometimes an employer may not totally understand, or they may interpret a provision within an enterprise agreement or within an award quite differently to what a trade union might interpret it, and there may be a legal challenge based on that, with the view that there's been an underpayment of wages. And obviously, if you have the backing of a union, if workers have the backing of a union, you can take those matters to the Fair Work Commission or to the federal court if it's a big enough issue, and that's exactly what we did some years ago, and paramedics were paid the money that they were entitled to in regard to that leave loading, which was a great outcome for paramedics at the time. Of course, we have these systemic problems right across many, many different workforces, and as I say, some of it is deliberately, the wages are deliberately withheld or underpaid, but in most cases, most employers are pretty good. Some will make mistakes, there's no question about that, as we all make mistakes. Of course, the group that are most affected with underpayments are the younger generation, where I think is about 1 in 3 young Australians report wage theft. There's probably a lot more that don't report it because they're too afraid to report it, because most of them are casually employed. And of course, if they raise issues within the workplace, they don't receive the call to get the next shift, unfortunately, and it's really difficult to prosecute issues of underpayment when people are too scared to come forward. And I had a youth forum in Melton only a couple of years ago, and again it was around young people's entitlements and their rights within the workplace. And there was one particular person there that expressed her story, and after working through her issue, it appeared that she was only paid $4 an hour, but she worked at a hairdressing salon and she put up with this and was too scared to raise it. She eventually left that salon but did not prosecute that matter to receive that underpayment of wages. But as I say, when you work through all of her issues and what she expressed to us, only receiving $4 an hour seemed to be unbelievable, but unfortunately she put up with that until she had the courage to leave that employer, but she never ever challenged that employer. And we see that a lot across a lot of industries where young people work. But as I say, most employers are pretty good, but of course you've got to keep an eye on that and that's what the Mighty Trade Union does. Now, I've only got a few seconds to go. This is an important bill to repeal, and I commend the bill to the House.